Picture this: a courtroom, marble columns, the scales of justice gleaming under fluorescent lights. Now picture a judge, robed and dignified, forced to answer the question, can a parrot sexually harass a human being? Welcome to the theater of legal absurdity, where the dumbest lawsuits in history didn't just get laughed out of court, they rewrote the rulebook. The legal system is supposed to be a fortress of reason, yet every few years someone files a claim so magnificently stupid that it punches a hole through logic itself, forcing society to create entirely new laws just to prevent it from happening again. What follows is a journey through 50 spectacular courtroom disasters, lawsuits against God, demons, and designer chocolate spread that accidentally shaped the modern world. 1. The Wizard Accusation. A Pennsylvania man sued magician David Blaine for $2 million, not because of injury or fraud, but because he genuinely believed Blaine was a warlock using satanic powers to violate physics. He claimed Blaine was stealing God-given powers through witchcraft. The court dismissed the case with what one imagines was Herculean restraint, but the lawsuit stands as a modern Salem witch trial. It officially confirms, though no one thought confirmation was necessary, that you cannot sue someone in federal court for being a wizard. Somewhere, J.K. Rowling breathed a sigh of relief. 2. The dog who inherited a fortune. When billionaire hotel magnate Leona Helmsley died in 2007, she bequeathed $12 million to her Maltese dog, Trouble. 2 of her grandchildren received nothing. Predictably, they sued. The resulting courtroom circus ended with a judge slashing the dog's inheritance to a mere $2 million. But the real legacy wasn't the dog's trust fund. It was the legal tool born from this spectacle, the pet trust. Lawmakers in multiple states passed statutes formally recognizing these arrangements, allowing Americans to legally provide for their animals posthumously. A billionaire's deranged love for her dog fundamentally altered American estate law. Trouble the dog changed more lives than most humans ever will. 3. The Cereal Berry Conspiracy. For 4 years, a California woman ate Captain Crunch's Crunch Berries cereal under the sincere belief that Crunch Berries were actual fruit. In 2009, she sued PepsiCo for false advertising. The judge dismissed her claim with thinly veiled contempt, noting that the vibrantly colored, uniformly shaped pieces in no way resembled real berries. This case became a law school legend, cementing the reasonable consumer standard, a legal doctrine affirming that the law will not protect you from your own failure to recognize that rainbow-colored sugar spheres are not health food. Common sense, it turns out, is a prerequisite for legal protection. 4. The Psychic Martian Ambassador. In 1997, a self-proclaimed psychic sued NASA for $300 million, claiming the Mars Pathfinder rover was trespassing on her property. She identified herself as a Martian ambassador and argued the rover was disrupting the planet's delicate vibratory balance, interfering with her psychic abilities. The court dismissed the case faster than light travels from Mars to Earth, unofficially establishing the extraterrestrial standing doctrine. Translation: to sue in a U.S. court, you generally need to be from planet Earth. Sorry, Martians. Your legal recourse ends at the atmosphere. 5. The Monkey's Copyright Selfie. A macaque monkey in Indonesia grabbed a photographer's camera and snapped a perfect, grinning selfie. It went viral. Then PETA got involved, filing a lawsuit on behalf of the monkey, whom they named Naruto, claiming he owned the copyright. The central question was mind-bending. Can an animal own intellectual property? The case climbed to a federal appeals court before judges ruled that no, animals cannot sue for copyright infringement. But the battle forced the U.S. Copyright Office to explicitly update its guidelines. Works created by non-humans, monkeys, ghosts, divine beings, are not protected. A monkey's selfie literally rewrote American copyright policy. Naruto lost his case but won internet immortality. 6. The Happy Birthday Heist. For over a century, Happy Birthday to You was a corporate cash cow. Warner Chappell Music claimed copyright ownership and charged thousands for its use in films, TV shows, and restaurants. In 2013, a documentary filmmaker forced to pay licensing fees fought back. Her lawsuit unearthed a bombshell. The copyright claim was invalid. The 1935 copyright covered only a specific piano arrangement, not the melody itself. A judge ruled the song had always been public domain. One lawsuit dismantled a multi-million-dollar monopoly and returned the most famous song in English to humanity, free, forever. 7. The sleeping fans scandal. Andrew Rector fell asleep during a Yankees-Red Sox game. ESPN cameras lingered on him while commentators cracked jokes about his nap. Rector was not amused. He sued ESPN, the commentators, and Major League Baseball for $10 million, claiming they portrayed him as fatty, stupid, and socially bankrupt. The judge dismissed the case, noting the commentary was gentle and, crucially, Rector was indeed asleep. The ruling was a victory for live broadcasters, affirming their right to comment on crowd events without fearing lawsuits from every unflattering camera shot. If you doze off on live TV, you've consented to becoming content. 8. The Gorilla Defamation. A San Diego woman repeatedly emailed her local news station. During a weather segment, the forecaster jokingly displayed a gorilla photo, claiming it was the persistent emailer. The woman sued for defamation. The station argued it was harmless humor. The court disagreed, ruling that even jokes can be defamatory if they hold someone up to public ridicule. The woman was awarded $500,000. The case drew a legal line for media personalities. You cannot call someone a gorilla on television and hide behind "just kidding." Humor has boundaries. Those boundaries are expensive. 9. The Nutella health food fraud. A New York mother fed Nutella to her children for years, convinced by advertisements highlighting skim milk and hazelnuts that it was a nutritious breakfast choice. She was shocked to discover it was essentially frosting in a jar. She sued. Ferrero settled for $3 million, offering customer refunds. The settlement sent shockwaves through food marketing. You cannot cherry-pick healthy-sounding ingredients while concealing mountains of sugar and fat. It was a watershed moment in the legal battle over what healthy means in advertising. Nutella remained delicious. It just couldn't pretend to be virtuous anymore. 10. The Red Bull Wings lawsuit. A Michigan man drank Red Bull for years. He never grew wings. He never experienced enhanced physical or intellectual performance. So naturally, he sued for false advertising. What could have been dismissed as obvious hyperbole took a shocking turn. Red Bull settled a $13 million class action suit. Anyone who'd purchased the drink in the previous decade could claim $10 cash or $15 in products. The case established a bizarre precedent. While you might not win on puffery alone, if your claim is specific enough, you can scare a corporation into paying you to disappear. 11. The weather forecast flew. An Israeli woman sued a television station because they predicted sunshine and it rained. She dressed lightly, went outside, caught the flu, missed work, and incurred medical expenses. The insane part? She won. The station paid over $1,000 in settlement. Though it occurred outside the U.S., the case became a global cautionary tale for meteorologists. It's why weather forecasters now use probabilistic language like 40% chance of rain, a legal shield protecting them from Mother Nature's whims. Meteorology became less about science and more about liability management. 12. The Michael Jordan Doppelgänger. Portland resident Alan Heckard filed an $832 million lawsuit against Michael Jordan and Nike. His grievance? He looked too much like the basketball legend. Heckard claimed the resemblance was so strong that constant public harassment caused him emotional anguish. He couldn't gym, bus, or church without being mistaken for his airness. The lawsuit was dropped after becoming a global punchline, but it solidified a crucial legal precedent. You cannot sue someone for sharing your facial features. Your likeness is not a trademark defendable in court. 13. The Fuzzy Dice Felony. Fuzzy dice dangling from rearview mirrors scream retro Americana. In 9 U.S. states, including California and Texas, they're completely illegal. The law doesn't target dice specifically. It bans anything hanging from mirrors that obstructs driver views. This regulation criminalizes pine tree air fresheners, parking permits, even religious medallions. Illinois recently modified enforcement amid racial profiling concerns. Acknowledging these laws enabled selective stops in communities of color. Your fuzzy dice aren't just style anymore. They're a potential legal interaction waiting to happen. 14. The Batman City lawsuit. In 2008, the mayor of Batman, Turkey, announced his intention to sue Warner Brothers and Christopher Nolan. He claimed the Dark Knight franchise used his city's name without permission, causing residents psychological trauma and a crime spike, as if the movie activated real-life supervillains. The lawsuit never reached a courtroom, becoming an international punchline instead. It established the unwritten "Don't Sue Batman" rule, a law of common sense reminding cities that legal battles with multi-billion-dollar franchises are catastrophically bad ideas. Batman the character remains undefeated. Batman the city learned a harsh lesson. 15. The Demon Defense. In 1981, Arn Cheyenne Johnson stabbed his landlord to death. His defense was unprecedented. He wasn't responsible because demonic possession controlled him. His lawyers literally argued that the devil made him do it. The judge flatly rejected the argument, stating such defenses were impossible to prove and had no place in rational legal systems. The ruling established rock-solid precedent. Demonic possession is not a viable insanity defense in the United States. The case drew a permanent line separating the laws of man from supernatural lore. Hell would need better lawyers. 16. The Subway Footlong Scandal. In 2013, a viral photo revealed a Subway footlong sandwich measuring only 11 inches. Internet outrage exploded, spawning a massive class action lawsuit. The case dragged on for years, racking up millions in legal fees. The final settlement? Lead attorneys pocketed over $500,000. Customers cheated out of an inch of sandwich received absolutely nothing. The judge called the settlement utterly worthless. The case didn't change sandwich length laws, but it became a monumental example of how class actions can be exploited solely for attorney enrichment, sparking serious reform debates. 17. The Parrot sexual harassment case. Katina sued her neighbor for $1.5 million because his parrot, Charlie, was allegedly sexually harassing her. She claimed the bird shouted obscene phrases whenever she entered her backyard. The neighbor insisted Charlie was merely mimicking television dialogue. The case was dropped, but not before becoming an international sensation. It exemplifies how even the most bizarre neighborly disputes reach the legal system, forcing judges to contemplate questions like, can a bird be held legally responsible for its foul mouth? Charlie the parrot remains at large, unrepentant and unindicted. 18. The horse seatbelt ticket. A California man was given a ticket for not wearing a seatbelt while riding his horse in a protest parade. The officer claimed California law defined horses as vehicles. The man fought the citation in court. The judge, maintaining what must have been heroic composure, ruled that for seatbelt law purposes, a horse is not a vehicle. The case forced California to clarify its vehicle code, ensuring no other equestrian would face the absurd prospect of buckling up a 1,000-pound animal. Sometimes, common sense requires judicial intervention. 19. The Harrier Jet Hustle. In the 90s, Pepsi ran a Pepsi Stuff campaign where customers collected points for prizes. The commercial jokingly showed a kid landing a Harrier jet at school. 7 million Pepsi points. Business student John Leonard saw an offer, not a joke. He exploited a loophole allowing point purchases, raised $700,000, and sent Pepsi a check demanding his fighter jet. Pepsi refused. Leonard sued. The court sided with Pepsi, ruling no reasonable person would believe the ad was a genuine military aircraft offer. Leonard v. PepsiCo became a contract law cornerstone, a permanent reminder that advertising hyperbole is not legally binding. Every over-the-top commercial today is protected by the ghost of that lawsuit. 20. The burrito sandwich debate. What legally qualifies as a sandwich? This wasn't a stoner philosophy session. It was a 2006 Massachusetts court case. Panera Bread had a mall contract granting exclusive sandwich selling rights. When Qdoba prepared to open, Panera sued, arguing burritos are sandwiches. What followed was gloriously absurd. Dictionary definitions and expert testimony on bread's nature. The judge ruled burritos are not sandwiches, citing handheld consumption and fillings like rice and beans, which aren't traditional sandwich ingredients. This decision created actual legal precedent influencing real estate contracts and franchise agreements nationwide. Philosophy became case law. 21. The Froot Loops Fruit Fiction. A California man filed a class action against Kellogg's in 2009, claiming Froot Loops misled him into believing the cereal contained actual fruit. The judge dismissed the case, pointing out the spelling fruit clearly indicated the product wasn't health food. The ruling reinforced the reasonable consumer standard, legally affirming that rainbow-colored sugar puffs are obviously not nutritious. The law refuses to protect you from your own inability to read cereal boxes critically. 22. The Starbucks Ice Conspiracy. A Chicago woman sued Starbucks for $5 million in 2016, claiming fraud because her 24-ounce venti drink wasn't actually 24 ounces of coffee. Half the cup was ice. The judge dismissed the case, dryly observing that a child understands ice displaces liquid. This became a key modern example of the reasonable consumer standard, a legal principle stating the law won't protect you from fundamental physics. Frozen water obeys natural laws. Lawsuits do not change thermodynamics. 23. The Self-Suing Inmate. Virginia inmate Robert Lee Brock sued himself for $5 million. He claimed that, by getting drunk and committing crimes, he'd violated his own civil rights and religious beliefs. The masterstroke? Since he was imprisoned with no income, he demanded Virginia pay the damages to himself. The judge dismissed the case with judicial restraint, noting the beautiful paradox. This wasn't a lawsuit. It was a philosophical Escher painting. The case is enshrined in law schools as a perfect, frivolous claim illustration, legally cementing that you cannot use courts for the world's dumbest financial loop-de-loop. Kafka would have been proud. The legal system was not. 24. The God Lawsuit. In 2007, Nebraska State Senator Ernie Chambers filed a lawsuit against God, the actual omnipotent deity, seeking a permanent injunction to stop fearsome floods and horrendous hurricanes. The incredible part? A judge actually heard the case. It was dismissed not for biblical insanity but procedural failure. Being ethereal, God couldn't be physically served a summons. The court couldn't find his address. This created wild legal precedent in Nebraska. Suing the universe's creator is theoretically possible, but the case gets stuck in logistical hell. God remains undefeated in court, not by divine right, but lack of a valid P.O. box. 25. The $54 million pants. In 2005, Washington, D.C. Administrative Law Judge Roy Pearson brought trousers to a dry cleaner who misplaced them. A normal person would be annoyed. Pearson decided this offense warranted a payout funding a small country's space program. His logic: the satisfaction guaranteed sign was an unbreakable legal contract worth a small island nation's GDP. The case dragged on for years, nearly destroying the immigrant family who owned the business. Pearson ultimately lost, but the weaponized pettiness became a national embarrassment, forcing the legal system to create stronger rules against frivolous lawsuits, essentially writing, "No, you can't sue someone into oblivion over lost pants." Ironically, the person who most needed to hear this was a judge. 26. The Magic Trick Injury. A British man attending a David Copperfield Las Vegas show was chosen for an illusion where participants seemingly vanished from stage. During the trick, he was rushed through dark secret corridors, fell, and was seriously injured. He sued. To defend himself, Copperfield's legal team had no choice but to explain under oath exactly how the famous illusion worked. The magician won the case, but at enormous cost. The lawsuit forced the magical world's hand, creating legal precedent on audience participation liability while simultaneously killing a cherished piece of magic forever by revealing its secret. 27. The Budweiser Beach Babe Promise. In the 90s, Richard Overton sued Anheuser-Busch for $10,000 over Bud Light commercials showing guys cracking beers on beaches, causing beautiful women to magically appear. Overton argued this was blatant false advertising. He'd consumed their product, yet no tropical fantasies or beautiful women materialized. He sued for emotional distress. The court dismissed the case, solidifying the legal concept of puffery, the idea that fantastical, exaggerated advertising claims aren't meant as literal fact. This ruling is why you can't sue energy drink companies for failing to give you actual wings. 28. The Vexatious Litigant Law. What happens when one person won't stop filing baseless lawsuits? California created a solution: the Vexatious Litigant designation. This law emerged from costly chaos caused by individuals clogging courts with hundreds of frivolous cases. Once labeled vexatious, you're legally forbidden from filing new lawsuits without judicial permission. The law was famously applied to a man who filed over 300 separate suits stemming from a single minor car accident, suing everyone from the other driver to the tow truck operator. This isn't just law. It's a legal restraining order against people treating courthouses like personal playgrounds. 29. The Creed concert Catastrophe. The band Creed was sued by 4 fans after a Chicago concert. The fans claimed lead singer Scott Stapp was so intoxicated he couldn't sing lyrics, just mumbled and rolled on the floor. They demanded full refunds, arguing the performance didn't legally qualify as a concert. The court dismissed the case, but it raised a fascinating question. Is there a minimum quality standard for live performances? The ruling implicitly suggested no. When you buy a ticket, you're paying for the chance at a good show, not a guarantee. Terrible concerts are protected by the doctrine of buyer beware. 30. The haunted house injury. A woman at Universal Studios' Halloween Horror Nights was so frightened by a character jumping out that she fainted, fell, and broke her wrist. She sued, claiming the haunted house was too scary and Universal had a duty not to frighten customers to injury. The court sided with the theme park, establishing precedent based on assumption of risk. The law officially recognizes that haunted houses exist to be scary. By buying a ticket, you consent to being frightened. You cannot sue for getting exactly what you paid for. Terror has terms and conditions. 31. The Winnebago Urban Legend. An urban legend tells of a man who bought a Winnebago RV, set cruise control to 70 miles per hour on the highway, then walked to the back to make a sandwich. The RV crashed. He supposedly sued Winnebago for not warning him this was inadvisable. While this specific case is almost certainly fiction, it perfectly embodies decades of frivolous lawsuit pressure on manufacturers. The fear of being this defendant is why your hairdryer warns, do not use while sleeping. The idea of this lawsuit created a real-world legal strategy. Defensive labeling, protecting companies from our worst instincts. 32. The Subway for Life dispute. A Michigan man won a Subway for Life contest, then sued the company over his prize. Instead of a magical card granting infinite sandwiches until death, he received roughly $13,000 in gift cards. He argued for life should mean, well, for life. The resulting case legally defined lifetime supply. The judge sided with Subway, ruling companies have the right to define their own contest terms. This sensible decision saved us from a world where prize winners could bankrupt corporations with endless, lifelong demands for free sandwiches. 33. The McDonald's coffee myth. Everyone thinks they know the McDonald's hot coffee lawsuit, the go-to example of legal stupidity. The reality is the polar opposite. In 1992, 79-year-old Stella Liebeck suffered third-degree burns requiring skin grafts after spilling McDonald's coffee. The coffee wasn't just hot. It was served at temperatures capable of melting car paint, far hotter than home machines. Court evidence revealed McDonald's knew about over 700 previous burn incidents and did nothing. The jury's large award wasn't about a simple spill. It was punishment for corporate negligence. But McDonald's launched a massive PR campaign framing Liebeck as greedy. They won in public opinion, creating a myth persisting today. The case didn't create a dumb law. It reinforced corporate responsibility. But it also created a cynical playbook on manipulating narrative and convincing millions that the victim is the villain. 34. The parenting malpractice claim. A 28-year-old New York man sued his parents for $200,000 for malpractice of parenting. He claimed they hadn't loved him enough, were emotionally unsupportive, and were ultimately responsible for his unemployment and adult unhappiness. The court dismissed the lawsuit instantly, stating there's no legal standard for good parenting enforceable through litigation. The ruling was a crucial family defense, creating a legal firewall preventing courtrooms from becoming theaters for every childhood grievance and perceived parental slight. Some wounds don't have a dollar value. Most don't even have a legal remedy. 35. The Memoir Defamation. In 2021, Mariah Carey's brother sued her for defamation over passages in her best-selling memoir, claiming her depiction caused immense emotional distress. The case put memory and autobiography on trial. Can you be sued for telling your own life story? The judge dismissed most claims, ruling Carey's statements were opinion or personal childhood recollections, not objective facts. The case set powerful modern precedent, reinforcing legal protection for memoirists. It affirmed that the law understands family history isn't a court transcript, it's a collection of personal, often conflicting stories. 36. The Kinder Egg Conspiracy. Kinder Eggs, chocolate shells with toy surprises inside, are beloved worldwide. In the United States, they're banned. The Federal Food, Drug, and Cosmetic Act prohibits embedding non-nutritive objects in food. This wasn't always the case. The law emerged from lawsuits and safety concerns about children choking on small toys hidden in edible products. What began as consumer protection evolved into a bizarre cultural phenomenon where Americans can legally own assault rifles, but not surprise eggs. The legal system drew a line. Guns are constitutional, chocolate surprises are contraband. 37. The Internet's Foundation Lawsuit. In the late 90s, the gossip site The Drudge Report falsely accused a White House aide of spousal abuse. The aide sued not just Matt Drudge, but also America Online, the ISP hosting the report. This was a critical moment. If AOL was held liable, every ISP, forum, and website would be legally responsible for user content. It would have killed the Internet as we know it. The court ruled in AOL's favor, becoming the foundation for Section 230 of the Communications Decency Act, the law stating online platforms aren't liable for user posts. It's the bedrock of the modern Internet, the reason YouTube, Facebook, and Twitter exist, all born from a dumb, false piece of gossip. 38. The Sock Puppet Wars. In 2000, an advertising executive created commercials for his company featuring a sock puppet. The ads succeeded brilliantly. PetSmart then launched their own campaign with a sock puppet mascot. The exec sued for idea theft. The court grappled with a tricky question. Can you copyright the idea of a sock puppet? The judge ruled no. The concept is too generic to be owned. This case helped define intellectual property limits. It established that you can copyright specific characters, but not entire archetypes, ensuring culture doesn't become a legal battlefield where someone sues you for writing about vampires or wizards. 39. The Cowboys Fan Prisoner. A prisoner serving life in Colorado sued the NFL for $100 million. His claim? Referees made a bad call during a playoff game costing the Dallas Cowboys victory. He argued that, as a lifelong Cowboys fan, the unjust ruling caused severe emotional distress. The lawsuit was quickly dismissed as frivolous, but it perfectly encapsulates how deeply sports and law can collide. The ruling reinforced that you can't sue over game outcomes. Courts consistently refuse to become replay booths, legally establishing that a referee's bad call, no matter how infuriating, is not lawsuit grounds. 40. The Twinkie Defense. In 1978, politician Dan White shot and killed San Francisco Mayor George Moscone and Supervisor Harvey Milk. The media spun his defense as claiming he was hopped up on sugar, making him crazy. The reality was more complex. Lawyers argued his sudden switch to a diet of Twinkies and soda was a symptom of severe depression, causing diminished mental capacity. The jury bought it, convicting him of a lesser charge. Public fury was absolute. The verdict created such backlash it led to a new California law abolishing the diminished capacity defense. A case that became a national punchline about junk food had profound legal consequences, rewriting murder trial rules. 41. The Drive Trailer Deception. When the film Drive was released, its trailer promised high-octane car chases like Fast and Furious. The actual film was a slow-burn, atmospheric art house thriller. A Michigan woman was so disappointed she sued the distributor for misleading advertising. The court dismissed the case but sparked serious debate. The ruling established that movie trailers are artistic works themselves, allowed creative leeway. They don't have to be literal scene-by-scene summaries, legally protecting trailer artistry from being regulated like toaster advertisements. 42. The body odor discrimination. A woman was fired from a Procter & Gamble subsidiary, then sued claiming termination occurred because her boss couldn't tolerate her body odor, caused, she said, by a medical condition. The lawsuit tested Americans with Disabilities Act limits. Does protection against discrimination extend to offensive employee smell? The court sided with the employer, ruling that while the ADA requires reasonable accommodations, it doesn't require companies to tolerate disruptive workplace odors. The decision drew a difficult but important line defining where one employee's rights meet coworkers' rights. 43. The Pastafarian Colander case. A University of Nebraska student sued the Dean and Board of Regents for discriminating against Pastafarians, followers of the Church of the Flying Spaghetti Monster, a satirical religion protesting creationism in schools. The student argued that as a devout Pastafarian, he had the right to wear a pirate colander on his head in his student ID photo. The court dismissed the case, ruling Pastafarianism, while brilliant satire, doesn't qualify as a real religion deserving legal protection. The ruling legally defined the difference between sincere faith and a really, really good joke. 44. The EOS Lip Balm Panic. In 2014, a Los Angeles woman sued EOS lip balm makers, claiming the product caused her lips to blister, crack, and rash. She filed a class action that went viral, causing panic among millions of customers. The company fought back with safety data. The lawsuit was eventually settled with the woman dropping her case, but damage was done. The case became a textbook example of trial by social media, where unproven legal accusations inflict massive reputational and financial damage long before judges hear evidence. It highlighted a new reality. The court of public opinion is far more powerful and chaotic than courts of law. 45. The Harley-Davidson sound trademark. Can you own a sound? Harley-Davidson thought so. In 1994, the company filed to trademark the unique potato-potato sound of its V-twin engine, arguing it was key brand identity. Competitors immediately challenged, kicking off a 6-year legal war over a noise. Harley-Davidson finally dropped the application, realizing it was unwinnable and expensive. But the attempt forced the U.S. Patent and Trademark Office to clarify. A sound that's a functional byproduct of machine operation cannot be monopolized. You can't legally own the sound your product makes. A ruling that kept our soundscape from being carved up by corporate lawyers. 46. The Compulsive Gambler Defense. Mark Johnston gambled away $500,000 in a single Las Vegas weekend. Months later, he sued the casino to recover his losses, arguing he was a known compulsive gambler and visibly intoxicated. Therefore, the casino had a duty to stop him. The case presented a fundamental question to the Nevada Supreme Court. Who's responsible for gambling losses? The court ruled against Johnston, declaring casinos have no legal duty to save patrons from their own compulsive behavior. This landmark decision sent shockwaves through the industry, setting precedent protecting casinos from being financially responsible for customers' personal demons. 47. The Dell Outsourcing Outrage. In 2005, a Texas man who purchased a Dell computer with a service plan sued over his frustrating experience with Indian customer support. He filed a class action on behalf of everyone subjected to Dell's outsourced tech support. Miller v. Dell became a flashpoint for globalization and customer service debates. While settled out of court, it sent a powerful corporate message. Outsourcing may be cost-effective, but if service quality plummets, it creates massive legal and financial liability. It was a lawsuit putting the entire offshore customer support practice on trial. 48. The BMW Cruise Control Catastrophe. A man rode his BMW motorcycle equipped with a throttle locking mechanism similar to cruise control. He activated it, then let go of the handlebars to retrieve something from his backpack. Predictably, he crashed. Then he sued BMW. He argued the company failed to warn him that releasing handlebars on a moving motorcycle was inadvisable. The court threw the case out, but it perfectly exemplifies why products are now covered in ridiculously obvious warnings, like iron labels saying, "Do not iron clothes while wearing them." Common sense isn't common, so it must be printed on everything. 49. The Burglar Defense. You've heard the story. A burglar breaks in, gets injured, successfully sues the homeowner. While the most famous versions are urban legends, they're rooted in real legal principle. Homeowners have some duty of care, even to trespassers. Specifically, no malicious booby traps, cases where criminals injured themselves then sued, while rarely successful, caused widespread public fear and outrage. This led to a wave of castle doctrine and make my day laws across America, specifically written to provide homeowners enhanced legal immunity from lawsuits filed by intruders they injure while defending property. A direct response to some of the dumbest, most audacious lawsuits imaginable. 50. The most litigious man alive. In 2007, federal inmate Jonathan Lee Riches filed what is likely the most ambitious lawsuit in human history. He sued the Guinness Book of World Records for $5 million, claiming they had no right to name another man the world's most litigious, a title he felt he deserved. He'd filed thousands of lawsuits against everyone from Plato and Nostradamus to the Eiffel Tower and the Holy Grail. The court dismissed the case, but the audacity is a monument to legal absurdity. It's a lawsuit perfectly embodying frivolous litigation. A man suing a book for not recognizing his achievement of filing too many lawsuits. The verdict: from lawsuits against God to legal battles over sandwiches, the path of law is not straight. It's messy, chaotic, and often hilarious, a reflection of our own magnificent absurdity. These cases aren't just funny stories. They're stress tests that bend, break, and ultimately shape the rules governing our lives. A monkey's selfie rewrote copyright policy. A billionaire's dog changed estate law. A man who wanted a fighter jet redefined contract law forever. The legal system is supposed to be a fortress of logic, but human creativity, at its most unhinged, constantly tests those walls. Sometimes the only way to protect reason is to write a new law saying, no, you can't sue someone for being a wizard, or no, burritos are not sandwiches. What began as chaos became order. What started as stupidity became precedent. And in the grand theater of human folly, these lawsuits remind us that sometimes the dumbest moments create the most important rules. The rabbit hole of legal insanity goes deeper than you can possibly imagine. Somewhere, right now, someone is filing a lawsuit so magnificently stupid that it will one day reshape the law. And when that happens, we'll look back and laugh, right before we create an entirely new statute to make sure it never, ever happens again. Because that's how stupidity writes the law.